Blog Talk Radio.
Welcome to Family Law Talk.
Family Law Talk.
Presented by Kirk Stange of Stange Law Firm, PC. Stange Law Firm is a family law firm with offices in Missouri and Illinois. Now, here's your host, Kirk Stange.
Welcome to Family Law Talk. My name is Kirk Stange, and today's topic is, are pre-embryos human beings under the law? This is an interesting topic, and it is based on an article that we have on familylawheadquarters.com, and the title of that article is, Are Pre-Embryos Human Beings or Property in Divorce? So as a follow-up to that episode today, you can certainly go on over to familylawheadquarters.com and read this article as well. And you will find at the article itself a link to the case that we're about to talk about as well. So this is a published opinion. You can actually read the case online as a follow-up today if this is a topic that's of interest to you. But here's a topic, and let's go ahead and jump on in, which is in Missouri. In November, there was a really interesting Court of Appeals decision that came out on the topic of pre-embryos and whether or not in divorce proceedings they are considered human beings. In other words, children, where traditional custody laws would apply. In other words, the best interest of the child, and just like any children born, they would ultimately be treated as children, and you would have more traditional custody schedule application to the scenario. Or on the flip end, are pre-embryos property? In other words, like other property that parties might have when they're married that needs to be divided in a just manner when considering all the factors. So are they human beings under the law, or are they property under the law, in which case they would be divided as any other property in divorce proceedings? So that's the topic, a really interesting topic, and I'll just say this as well, a very complicated fact pattern. So read the case itself if you like. Again, there's a link to the case itself in the published opinion, and you can read it, and it'll give you a lot of background and a lot more background than what we can cover today. But let me try to explain it to you the best I can. And again, I'm trying to sum it up, and I know in some ways I'm probably oversimplifying the fact pattern, and there might be some specific facts that I inadvertently forget to mention, but I'll try to summarize it the best that I can. And again, it's a complicated fact pattern, so it's hard to get it 100% right, but you can certainly read the case itself and the link to it. But in essence, husband and wife in this case were in divorce proceedings, and apparently if you read the case, these divorce proceedings had been going on for some period of time. And somewhere around 2007, they cryopreserved some pre-embryos that they had created through IVF treatments, right? So the parties have IVF treatments. They create these embryos, or pre-embryos, if you will, and then they're cryopreserved. Now, you might say, what's the difference between an embryo and a pre-embryo? Well, a pre-embryo hasn't been implanted in the uterus yet, right? So these are created through IVS. They're then cryopreserved to be implanted at a later date when the parties are actually trying to conceive. Now, during the IVS process, the parties apparently signed an agreement with the fertility clinic, and this became a big issue of dispute in the case itself, and if you read the facts, you'll really see it in there. But the document itself indicated that wife would receive the embryos in the event of divorce, but then there's a lot of discourse about the circumstances in which this agreement was ultimately signed, and there's some allegations made. And again, I'm not taking sides. I certainly don't know what happened or what didn't happen. I can just read the case. But there's a question, at least, in terms of looking at the case, and this is what the appeals court opinion references, which is, was critical information written in after husband signed this document, or was that not the case? And the court looked at the color of the ink. They looked at some of the facts involved in terms of how the agreement came to fruition. Apparently it was presented by wife to husband. And apparently, from reading the opinion, it talks about maybe some of the signing of the document took place on two different dates. But long story short, the agreement indicated that wife would get these pre-embryos in the event of divorce. But ultimately, as the court looked at the agreement, they seemed to have a big question about it, and the trial court, at least, did not enforce the agreement based on a lot of these concerns. And the appeals court ultimately upheld that. So the agreement doesn't end up carrying the day. And I'll just say this as well. We're focusing on this one particular case for purposes of the podcast today. But there have been similar cases in other jurisdictions as well. And you get into a real question, even if the contract had been entered in a way in which no doubts were raised, which is whether or not contract law even really applies when you're dealing with something as sensitive and personal as embryos. But in this case, ultimately the court didn't have to get into that because they found at the end of the day that this agreement wasn't enforceable. But in terms of the embryos themselves, or the pre-embryos, husband and wife in this case really differed in their opinion in terms of what should happen with them. Husband in the case wanted these pre-embryos to be donated to an infertile couple, donated to research, or to be destroyed. On the other hand, a wife wanted to have possession or custody, if you will, of these pre-embryos and ultimately be able to give birth to children, or at least attempt to give birth to children through implantation of these embryos. In this dispute between the two of them in terms of what was going to happen with these pre-embryos, again became very litigious. The parties couldn't agree. They both have different perspectives. McQueen, the wife in this case, wanted to be able to ultimately give birth, or at least try to conceive, and the husband in this case, Gadberry, didn't agree with that. And that culminated in this opinion by the Missouri Court of Appeals. Ultimately, when the trial court analyzed this case, what the trial court did is gave the parties joint possession at the end of the day of these pre-embryos. So both parties at the end of the day had joint possession, which at the end of the day didn't really give either party really the ability to make a unilateral decision with regard to what was going to happen with these pre-embryos. And so the court, again, found that both parties are considered to have an equal interest in them. And the court also, in terms of this debate, which is the title of the podcast episode today, when the court weighed, are these human beings or are they property under the law? So are they human beings or are they property under the law? The court, the trial court indicated that they were marital property of special character. And again, then awarded, in essence, both parties equal right to them, which at the end of the day really made it such that wife can't, at least in terms of this opinion, implant these pre-embryos and conceive children. And so that was ultimately the decision in this case, that they're marital property of special character versus being human beings, where traditional standards of custody would apply. Now, in looking at the case itself, really some interesting takeaways. And again, as a follow-up to the episode, you could definitely read the case opinion itself, and it goes into a lot more detail. But one of the things that the court indicated, if you read the opinion, was this, and I'll give you a quote, which is, although McQueen has the right to procreate, that does not mean she has the right to procreate with Gadberry by implanting the frozen pre-embryos which contain his genetic material. So that was one key quote, one key takeaway from the decision itself. Now, there was a dissenting opinion, so not all the judges in this case agreed. And the dissenting opinion indicated this, and I'll give you a quote, which is, Missouri law makes one thing abundantly clear. Two embryos at issue in this case are human beings with protectable interest in life, health, and well-being. And then it cites a Missouri statute, section 1.205, which at the end of the day gives some definition to what is human life in the state of Missouri. And the dissenting opinion indicates that under the statutory language, these pre-embryos are human life, and they should be treated as such and be given the protections of such. So a really interesting decision, again, in terms of weighing our pre-embryos, human life, Are they marital property? At least according to this case decision, they're marital property of a special character. Now, in saying that, again, this is a tough issue for a lot of individuals going through IVF, and I think for individuals who are going through it and they're going to create these pre-embryos, I think some takeaways from this case would be if you're going to create frozen embryos or pre-embryos as took place here, you want to spend a lot of time discussing the matter with your spouse or whoever the other parent is going to be, and make sure that you're both on the same page, that you both have a definitive agreement put in place in terms of what would take place. By doing that, you can help prevent disputes later. In terms of looking at the facts of this case, again, I can just read the case decision itself in terms of what was reported, and there might be more to the story theoretically than what in theory ended up in the public's opinion. But at least from reading the case, it appears that the parties in this case didn't agree, and they really didn't have a meeting of the minds out of the gates in terms of what they both wanted in the case of divorce. And so for parties who are going to go through IVF, that's really important. And so if you haven't considered it, you definitely do want to consider it. And by doing that, you can, at the end of the day, help prevent litigation on the back end if a marriage later ends in divorce or a relationship later doesn't continue on indefinitely. In other words, it ends. A few other takeaways from this case as well, which I would just state, which is I think a lot of us attorneys assume this case will make its way to the Missouri Supreme Court. So theoretically, this decision may or may not stand. Who knows for sure? But for now, this is the decision of Missouri at least. But again, it's certainly possible that this makes its way to the Missouri Supreme Court, and who knows for sure what might happen up there as well. A couple other takeaways as well, which is there's been some proposed legislation in Missouri at least to attempt to deal with this issue as well in terms of defining pre-embryos as human beings versus property in a divorce proceeding. So certainly if new legislation passes and were to be signed into law, that could change the analysis, at least in the state of Missouri. But who knows for sure what ultimately will happen there. Will the legislature pass new legislation? Would the governor sign it? Certainly nobody knows for sure, but it's certainly possible, and it's certainly realistic to think that might happen. So that will be a big piece to watch going forward in terms of not just this case, but other future cases. But I think just as a whole, this is an interesting case and one I wanted to cover because lots of individuals consider IVF, and more people are engaging in IVF, in vitro fertilization, in order to have children. And so it's certainly critical for parties to consider this, to think about it, to make sure that certainly a good agreement is put into place and that there's a meeting of the mind on the part of the parties. Otherwise, as can be seen from this case, it could be very expensive litigation, can be certainly hard for the parties going through it, and certainly when you get into a fact pattern like this, oftentimes you end up with one party really unhappy with the result. And so, again, before parties go through IVF, I just think it's critical that parties both be on the same page, and that can certainly help avert this kind of fact pattern. But big case in Missouri, one I wanted to cover, one that has some big implications in the future, and certainly those interesting takeaways to follow, which is, does the Missouri Supreme Court do something on this case and do something in theory differently? Who knows? And will legislation be passed in Missouri which could change the way this fact pattern is analyzed as well? Who knows? But it'll be definitely interesting to watch and definitely interesting to follow. Again, as a follow-up to this episode, go on over to familylawheadquarters.com. Check out the article we have there, Are Pre-Embryos Human Beings or Property in Divorce? And then again, a link in that article to the case decision itself so you can read all the facts. Again, I had to kind of sum it up quickly in the interest of time for this podcast today, but go over there, read all the facts, certainly an interesting case and one spending some time reading, especially if you're an individual considering IVF. Thanks for tuning in today. Stay tuned to our next episode coming up on Family Law Talk. Thank you very much.
Thank you for listening to Family Law Talk with Kirk Stange. Visit StangeLawFirm.com for more about today's topic or to put Stange Law Firm to work for your family today. The choice of a lawyer is an important decision that should not be based solely upon advertisements. Neither the Supreme Court of Missouri or Illinois reviews or approves certifying organizations or specialist designations. The information you obtain on this podcast is not, nor is it intended to be legal advice. You should contact an attorney for advice regarding your individual situation. We invite you to contact us and welcome your calls, letters, and electronic mail. Contacting us does not create an attorney-client relationship. Please do not send any confidential information to us until such time as an attorney-client relationship has been established. And finally, past results afford no guarantee of future results, and every case is different and must be judged on its own merits.
Kirk Stange is responsible for the content. Principal place of business, 120 South Central Avenue, Suite 450, Clayton, Missouri, 63105.
Treat your party host with a Hy-Vee party tray. From meat, cheese, and charcuterie boards to shrimp and seafood trays and everything in between, Hy-Vee has the perfect signature platter to make your event extra special. And make sure to check out the chicken wing trays if you want a real crowd pleaser. Shop in-store or online at high-v.com. That's high-v.com.
The holidays start here at Baker's with a variety of options to celebrate traditions old and new. You could do a classic herb-roasted turkey or spice it up and make turkey tacos. Serve up a go-to shrimp cocktail or use Simple Truth wild-caught shrimp for your first Cajun risotto. Make creamy mac and cheese or a spinach artichoke fondue from our selection of Murray's cheese. No matter how you shop, Baker's has all the freshest ingredients to embrace all your holiday traditions. Baker's, fresh for everyone.